Hello, ladies and gentlemen. Austin Petersen here, former presidential candidate for the Libertarian Party. Breaking news, a federal judge has ruled a halt to Donald Trump's executive order, which placed strict limitations on immigrants from foreign nations, which are in connection, allegedly, to terrorism. Now, most of the time we do these live streams on a regular schedule of Monday, Wednesday, and Thursday, but because of all of the major news surrounding this and because of all of the myths and lies and facts and things that are swirling around, I wanted to make sure that we would all be able to have an opportunity to talk about this important breaking news as it's happening. So I rushed home from some time with my family so that I could sit down and talk with you all about these important issues facing our nation. Now, I will be monitoring the comments on Facebook Live, so if you're watching this live on Facebook now, please feel free to drop your comments below. I've pulled some scholarly articles from the National Review as well as from Reason Magazine and one of my favorite authors, Judge Andrew Napolitano, to discuss the constitutionality of the questions that are facing us as a nation. Now, of course, there is a difference between what I believe personally and what is the law, what is legal, and what is constitutional. Quite often, libertarian beliefs may be in conflict with the Constitution, but many times they're not. And I always want to try and impart to you what is my bias versus what I believe is the law. And that's what I believe is important, because we've been discussing fake news and alternative facts and things like that. But I want to make sure that you understand that all reporters have a bias. Anyone who claims to be an unbiased journalist is definitely probably the person you should be the most suspicious of, simply because a reporter shows their bias is just in deciding which stories to cover. I mean, they may cover a story objectively, or they may purport to be objective about a story, but they show their bias just in deciding which stories to cover. And I'd like to show you my bias, of course. My bias is towards individual liberty. But I do believe that there is some constitutional basis for libertarian ideas. Now, I've pulled an article from the National Review as well as an article from Reason Magazine, and I want to be discussing with you the question of whether or not the United States Constitution applies to U.S. citizens or non-U.S. citizens. And a lot of people who have been arguing with me today about this topic have been saying that the Constitution of the United States doesn't apply to non-U.S. citizens. The problem with that way of thinking is, one, that it's blatantly false from a legal viewpoint. Two, it's blatantly false from a moral viewpoint. Of course, human rights being individual rights are not subject to your nationality. Individual rights are subject to your humanity. And any good conservative, true conservative, would say, of course, the Constitution does not grant you rights, right? The United States Constitution only recognizes your intrinsic rights. And I've got some good legal arguments to back that up. But I want to talk to you, of course, about the 14th Amendment, and I'll talk about that a little bit later in the show. But I've got an article from the National Review by David French, who's taken a fairly nuanced view of this. I'm not going to be able to read the entire thing, but I want to make sure that we're separating facts from hysteria in order to ensure that we get the facts correct, and then we can discuss our opinions on this in just a moment. So what did Trump do? Did he implement a Muslim ban? No. He backed down from his proposed ban and signed an executive order that was dominated mainly by moderate refugee restrictions and temporary provisions aimed directly at limiting immigration from jihadist conflict zones. This is David French. Now, we're going to look at the key provisions here. First, the order temporarily halts refugee admissions for 120 days to improve the vetting process, then caps refugee admissions at 50,000 per year. Outrageous, right? No, not so fast. Before 2016, when Obama dramatically ramped up refugee admissions in George W. Bush's 2 terms and a typical year in Obama's 2 terms. In 2002, the United States only admitted about 27,131 refugees. It admitted fewer than 50,000 in 2003, 2006, and 2007. As for Obama, he was slightly more generous than Bush, but his refugee cap from 2013 to 2015 was a mere 70,000, and in 2011 and 2012, he admitted barely more than 50,000 refugees himself. And so David French thinks that this is an improvement in security screening, and that Obama's expansion of the amount of refugees was a departure from recent norms and not Trump's contraction. Now, the order also imposes a 90-day ban on people entering the United States from Iraq, Syria, Iran, Libya, Somalia, Sudan, and Yemen. These are countries torn apart by jihadist violence, no question of that. Now, the ban is in place while the Department of Homeland Security determines the, quote, information needed from any country to adjudicate any visa, admission, or other benefit under the INA, which is the adjudications, in order to determine that the individual seeking the benefit is who the individual claims to be, and not a security or public safety threat. It could, however, be extended or expanded depending on whether countries are capable of providing the requested information. Now, the ban does contain an important exception. Quote, Secretaries of State and Homeland Security may, on a case-by-case basis, and when the national interest, issue visas or other immigration benefits to nationals of countries for which visas and benefits are otherwise blocked. In other words, the secretaries can make exceptions, a provision that would, one hopes, fully allow interpreters and other proven U.S. allies to enter the USA during the 90-day period. To this extent, this ban applies to new immigrants and non-immigrant entry. The temporary halt, he says, David French thinks is wise. He says that terrorists are trying to infiltrate the ranks of refugees and other visitors here. He says that Somalian immigrants have launched jihadist attacks here and have sought to leave the U.S. to join ISIS. So is there a security threat? Of course there is. Do we sacrifice liberty for security? I'll leave that up to you to decide, but I'll answer that for myself in just a few minutes. And this is what David French sees as a problem with this. There are reports that the ban is being applied even to green card holders. David French says this is madness. The plain language of the order doesn't apply to legal permanent residents of the U.S., and green card holders have been through round after round of vetting and security checks. The administration, he says, should intervene immediately to stop misapplication. If, however, the Trump administration continues to apply the order to legal permanent residents, it should indeed be condemned. And I'll drop this for you all in the comments so that you can all see the arguments that David French is making. Now, I may or may not agree with it. Of course, David French comes from the more neoconservative school of thought, not quite the libertarian school of thought. And so this is something that you need to take into consideration. Remember, consider the bias of the source, but I wanted to make sure that you knew that I was reading someone here that definitely disagrees with me on certain things, and I want to make sure that you know that while I may be biased, I'm fair. Okay? Drop that article in there. Now, let's talk about the 14th Amendment. Let's talk about whether or not the United States Constitution applies to non-U.S. citizens. The answer is absolutely, unequivocally, yes. The Constitution does apply to non-U.S. citizens who are within our jurisdiction. We used to have a wet foot, dry foot policy before Obama ended it, meaning that if a Cuban managed to make it to dry land, then they could be subject to our jurisdiction, meaning that they would be subject to all of the rights of citizens, not rights of citizens, but all of the rights that we all share: individual rights, rights to free speech, rights to self-defense. If someone comes here perhaps on a travel visa and they're not a U.S. citizen and they happen to be visiting a friend and that friend happens to have a firearm, do they have a right to self-defense to use that firearm against an aggressor or an attacker? Of course they do. Do they have a right to their free speech while they're here? Of course they do. But of course that's within our jurisdiction. So let me read the 14th Amendment to you, and then I'll talk a little bit about the history of the 14th Amendment and try to explain to you why I think that the 14th Amendment of the U.S. Constitution is the most libertarian amendment of the entire United States Constitution, and it explains unequivocally why the U.S. Constitution does apply to non-U.S. citizens. And let me just read this to you verbatim here. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, right? That's talking about the naturalization process, and the state of wherein they reside. New sentence. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, semicolon, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now you see the nor is the key word in that sentence, because it initially discusses citizens, and then it continues and says nor. Now nor is the key word, and for you English majors in there, that denotes that we're speaking of a different group of people, right? We're delineating between citizens and persons, right? Nor shall any state, nor They can't. So it says, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person, of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This clearly states that the 14th Amendment applies to persons within our jurisdiction. So we're not even really talking about immigration here necessarily. We're talking about whether or not the United States Constitution applies to non-citizens. And the 14th of the Amendment of the United States states unequivocally that it does, that the Constitution applies if you are within our jurisdiction. And that's the really important part. Now, the question is, does the United States government have control over immigration? Well, one profoundly libertarian legal scholar, Judge Andrew Napolitano, says no. He says that the Constitution of the United States gives the government only power over naturalization, not immigration. What's the difference? Well, first of all, before we can get there, we need to understand what the 14th Amendment is and how it applies in a modern context. It was originally a Civil War era amendment. It was to apply during the slave era. Of course, now we have had many Supreme Court decisions that have fallen back using the 14th Amendment as precedent. I'm going to read a little bit of that to you. Then I'm going to read Judge Andrew Napolitano's argument about the difference between naturalization and immigration. Then at the end, I'm going to play a video from the Institute for Justice, which if you're not familiar with the Institute for Justice, it is the most libertarian law firm in the United States. They fight civil asset forfeiture, and that is usually their big modus operandi. But they use the 14th Amendment, the privilege, and they want to strengthen the Privileges and Immunities Clause because they see the 14th Amendment as the most libertarian amendment in the Constitution, which gives us the opportunity to expand liberty. And I agree with them, and we're going to talk about that in just a moment, and I'll play that video for you at the very end to complete this. So let's go ahead and read the history of the 14th Amendment so that you all can understand it. The 14th Amendment of the United States Constitution was adopted on July 9th, 1868 as one of the Reconstruction Amendments. So during the Reconstruction era, the amendment addresses citizenship rights and equal protection of the laws and was proposed in response to issues regarding former slaves following the American Civil War. The amendment was bitterly contested, particularly by the states in the defeated Confederacy, which were forced to ratify it in order to regain representation in Congress. The 14th Amendment, particularly its first section, is one of the most litigated parts of the Constitution, forming the basis for landmark decisions such as Brown versus the Board of Education regarding racial segregation, Roe versus Wade regarding abortion, Bush versus Gore regarding the 2000 presidential election, and Obergefell versus Hodges regarding same-sex marriage. Now, they don't state here until way later the fact that McDonald versus Chicago, the gun case, which instituted an individual right to bear arms and incorporating the Second Amendment into the states, was also cited by Clarence Thomas in the prevailing arguments in the McDonald versus Chicago gun case, right? So the 14th Amendment has been used in order to expand liberty for our Second Amendment rights. And so the amendment's first section includes several clauses: the citizenship clause, privileges or immunities, due process, and equal protection. The citizenship clause provides a broad definition of citizenship, overruling the Supreme Court's decision in Dred Scott versus Sanford, which held that Americans descended from African slaves could not be citizens of the United States, right? A bad Supreme Court decision, an unconstitutional Supreme Court decision. The Privileges or Immunities Clause has been interpreted in such a way that it does very little. Now, the 14th Amendment has been given some teeth in recent years. Of course, when we see the McDonald versus Chicago case being cited by Clarence Thomas, that's to show that there's a renewed interest in this. And the Due Process Clause prohibits state and local governments from depriving persons of life, liberty, or property without legislative authorization. Right? So the President of the United States cannot deprive anyone of life, liberty, or property without legislative authorization. So this would be the argument for any good libertarian legislator in the future to block the president's kill list, for example, the extrajudicial assassinations by the President of the United States to kill terrorists via a drone without a proper act of Congress. The Equal Protection Clause requires each state to provide equal protection under the law to all people within its jurisdiction. This clause has been the basis for many decisions rejecting irrational or unnecessary discrimination against people belonging to various groups. The second, third, and fourth sections of the amendment are seldom litigated. However, the second section's reference to rebellion and other crime has been invoked as a constitutional ground for felony disenfranchisement, meaning taking away your rights if you're a felon. The fifth section gives Congress the power to enforce the amendment's provision by appropriate legislation. However, under City of Bourne versus Flores in 97, Congress's enforcement power may not be used to contradict a Supreme Court interpretation of the amendment. So you guys need to learn a little bit more about the 14th Amendment. I don't have time for a full breakdown of the constitutional implications and all the Supreme Court cases for it, but you have to understand that it does mean persons subject to our jurisdiction. So we're not talking about immigration now. We're talking about people who are within our jurisdiction, right? Even if you're a non-U.S. citizen and you're in the United States, the Constitution does apply to you, right? And of course, I asked the question earlier on my Facebook page, which some people were pretty upset because they were saying that, oh, Austin, the Constitution doesn't apply to non-U.S. citizens. Well, of course, then that would mean that it doesn't apply to the unborn, right? So if you're pro-life, then you cannot argue that the Constitution doesn't apply to non-U.S. citizens in one breath and then say that the Constitution of the United States should be used to protect the rights to the life, to liberty of the unborn. Because unless you have been born, you have not received a birth certificate or a Social Security card. So how can you be a U.S. citizen if you haven't even been born yet? The answer is you haven't. But the 14th Amendment should protect the unborn's right to life. And that is my argument for being pro-life. My purely secular, purely rational, purely logical argument, which states that all humans, all individuals have the same right to life, liberty, and the pursuit of happiness. Now, whether the Constitution applies depends on whether or not you are under our jurisdiction. And that's the big question. Now, the question of whether or not the Constitution gives the power to regulate immigration is the one that you are, all the conservatives and all of the alt-right people, all of the neocons and the the paleoconservatives are not going to like this because they don't like the Constitution, of course, when it disagrees with them. But Andrew Napolitano makes a terrific case about why the Constitution does not delegate to the federal government power over immigration, only over naturalization. Judge Napolitano writes, "The tone of the debate over the nation's immigration laws has taken an ugly turn as some of the office seekers offer solutions to problems that don't exist. The natural right of all persons consists of areas of human behavior for which we do not need and will not accept the need for a government permission slip. We all expect that the government will leave us alone when we think, speak, publish, worship, defend ourselves, enter our homes, choose our mates, or travel. The list of natural rights is endless. We expect this not because we are Americans, but because we are persons, and these rights are integral to our nature. We expect this in America because the Constitution was written to restrain the government from interfering with natural rights. When these first principles are violated to advance a political cause or to quell public fear, those whose rights are violated because of an immutable characteristic of birth, not because of personal culpability, become the victims of public indifference or official government repression. The American history of government treatment of Africans and their offspring and the European history of government treatment of the Jewish people are poignant and terrible examples of this. Today, the potential victims of public indifference and government repression are Hispanics in America. Hispanics here without documentation are being demonized because of the politics of nativism. Nativism, we are exceptional. We are better people than they are. We were here first, is very dangerous and leads to ugly results. The Declaration of Independence and the Constitution underscore the truism that all persons have the same natural rights, irrespective of where their mothers were when they delivered them. The right to travel is a natural right, even though it was not until 1969 that the Supreme Court recognized it as such. The court protects natural rights by imposing a very high bar for the government to meet before it can interfere with them, absent due process. The high bar is called strict scrutiny. It requires that the government demonstrate an articulated area of jurisdiction and a compelling state interest served by the least restrictive alternative before it can treat a person differently or uniquely because of his or her place of birth. A compelling state interest is one that is necessary to preserve life or the state's existence, and it must be addressed using the least force and causing the least interference with personal liberty possible. This test was written so as to give the government wiggle room in a crisis and to make it intentionally difficult, nearly impossible to write laws that apply only to discrete groups when membership in them is determined by birth. But the Constitution itself, from which all federal powers derive, does not delegate to the federal government power over immigration, only naturalization. Thus, when the government's motivation for enacting immigration laws is to further genuine compelling foreign policy goals, the laws will be upheld. But when the government's motivation is nativism, or fear, or hatred, or favoritism, strict scrutiny will operate to defeat those laws. Shortly after the first federal immigration statute was enacted in the 1880s, the Chinese Exclusion Act, the Supreme Court ruled that aliens, whether here legally or illegally, are persons, and the Constitution protects all persons from government deprivation of life, liberty, and property without due process. Please let me read to you again this paragraph so that it may sink into your brains. Shortly after the first federal immigration statute was enacted in the 1880s, the Chinese Exclusion Act, the Supreme Court ruled that aliens, whether here legally or illegally, are persons, and the Constitution protects all persons from governmental deprivation of life, liberty, and property without due process. In the same era, the court that held all babies born here of alien mothers are citizens. The 14th Amendment requires this, and its languages are inclusive. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Though written to protect former slaves, its language is not limited to them. Some well-intended folks have argued that the language of all persons doesn't really mean all because it is modified by and subject to the jurisdiction of the United States, but that language refers to the offspring of mothers who, though here, are still subject to a foreign government, like foreign diplomats, agents, or military. It does not refer to those fleeing foreign governments. It does not and cannot impose an intent requirement upon infants. My guess is that nearly all persons reading this are beneficiaries of that clause, or listening to me right now are beneficiaries because you were born here. When the history of our times is written, it might relegate that the majority repressed the rights of minorities by demonizing them using appeals to group prejudice, by blaming an entire ethnic group to the criminal behavior of a few members of those groups. That history might reflect that this was done for short-term political gain. If that happens, it will have changed America far more radically and dangerously than any wave of undocumented immigrants did, and that would be profoundly and perhaps irreparably un-American. Ladies and gentlemen, thank you very much for listening to the Freedom Report podcast tonight. Austin Petersen dropping the mic. Enjoy this presentation from the Institute for Justice on the 14th Amendment, and have a fantastic weekend.
Learned and well-respected lawyer from Ohio.
Bingham actually appears to have been one of the few members of Congress who understood that by virtue of the Supreme Court's decision in Barron v. Baltimore, the Bill of Rights did not apply directly against the states. In fact, Bingham had to bring a copy of Barron onto the floor of the House to prove that the Bill of Rights had no effect against the states.
John Bingham believed there was a hole in the original Constitution, which was that it didn't give the federal government the power to protect individual rights from interference by the states. The 14th Amendment was Bingham's effort to fix that.
The 14th Amendment protects three distinct interests: due process, equal protection, and the privileges or immunities, meaning rights, of United States citizens. Of those three, privileges or immunities are by far the most important because that clause protects individual rights from government infringement. In 1872, the Supreme Court had its first opportunity to interpret the Privileges or Immunities Clause in a case called Slaughterhouse. Handed down in 1873, the Slaughterhouse cases essentially read the Privileges or Immunities Clause out of the 14th Amendment.
In the Slaughterhouse cases, Justice Samuel Miller, writing for a bare majority of the court, held that the Privileges or Immunities Clause protected only a limited and relatively trivial set of so-called rights of national citizenship, such as the right to access navigable waterways and federal sub-treasuries, and to invoke the protection of the federal government when on the high seas.
This was an utterly absurd reading of the Privileges or Immunities Clause. No one thinks we fought a civil war and amended the Constitution because someone somewhere had difficulty accessing a sub-treasury. And no one thinks that today. There is virtually unanimous agreement among constitutional scholars that the slaughterhouse majority's interpretation of the Privileges or Immunities Clause is completely indefensible.
Taking their cue from the Supreme Court's refusal to enforce the 14th Amendment consistent with its text, purpose, and history, the states responded by expanding the existing black codes into the formal caste system of Jim Crow. Blacks and whites alike were subject to a host of regulations designed to prevent newly freed blacks, or freedmen as they were called, from becoming economically self-sufficient members of society. This unrelenting assault on liberty finally forced the Supreme Court to reconsider its understanding of the 14th Amendment.
Having effectively eliminated the Privileges or Immunities Clause as a meaningful part of the Constitution, the court eventually began protecting individual rights through a doctrine called Substantive Due Process. That has a historical pedigree that dates back to the Magna Carta, but the Supreme Court's use of substantive due process to do a job for which the Privileges or Immunities Clause was designed has resulted in a patchwork and incomplete jurisprudence of liberty. Some rights the 14th Amendment was supposed to protect, like freedom of speech, ended up protected anyway. But others, like economic liberty or the right to own a gun, just got ignored and waved away.
On any fair reading, there is not the slightest doubt that the 14th Amendment protects an individual right to own a gun for self-defense. So why did it take the Supreme Court nearly 150 years to recognize that right, and then by a margin of only one vote? The Second Amendment says the right of the people to keep and bear arms shall not be infringed. Despite that clear language, it took a carefully planned public interest lawsuit, which I helped design and litigate, District of Columbia v. Heller, to finally persuade the Supreme Court to interpret the Second Amendment as protecting an individual right to own a gun. But because the District of Columbia is a federal jurisdiction to which the Bill of Rights applies directly, Heller left open the question of whether the 14th Amendment protects the right to own a gun from interference by state and local officials, and if so, how? That was the question the Supreme Court took up 2 years later in McDonald versus City of Chicago.
Faced with this question in McDonald, the Supreme Court split into three camps. 4 of the justices wanted to use the traditional substantive due process method to find that the right to keep and bear arms was fundamental and should therefore be applied against the states. Another group of 4 justices wanted to use substantive due process to say that the right to keep and bear arms was not fundamental and therefore shouldn't apply. The deciding 5th vote fell to Justice Clarence Thomas.
Justice Thomas makes such a powerful case for the Privileges or Immunities Clause in his McDonald concurrence that none of the other justices, in the plurality or the dissent, challenge his reading of the relevant history or his conclusion that the right to own a gun is a privilege or immunity of American citizenship.
The 14th Amendment, and especially the Privileges or Immunities Clause, was a really radical change to the Constitution. It was supposed to give the federal government, and especially the federal courts, the power to protect rights that had been historically trampled by state and local governments. One of these fundamental rights was the right to earn an honest living. But for its entire existence, the Privileges or Immunities Clause has been a dead letter. McDonald starts to change that.
In the wake of McDonald, the Privileges or Immunities Clause is relevant, is alive, in ways it simply hasn't been since it was adopted. And in coming years, as law students sit down to read the different opinions in McDonald, it's going to become clear that only one of those opinions really tries to grapple with the constitutional history, really tries to grapple with the role the 14th Amendment plays in our constitutional structure. And that's going to make an enormous difference.
The 14th Amendment was a promise. It was a promise to the people of this country of limited government and respect for individual rights. But that promise was broken almost immediately by the Supreme Court's redaction of the Privileges or Immunities Clause from the 14th Amendment. The Institute for Justice has been working for 20 years to restore the Privileges or Immunities Clause, to restore the concept of individual liberty to its proper place in the Constitution and its proper place in our society.